Court is calling 2023 CR 2580, State of Texas versus Desiree Soriano. Could I have parties announced for the record for the state? Oh, it's a theft case plea.
Daniel S. Ford, State of Texas.
Defense.
Thomas Beck, Ward Defendant.
All right. And are you Ms. Soriano?
Yes, ma'am.
Counsel, you received all of the discovery. Did you review it with your client? I'm sorry, counsel. Did
Yes.
you receive all the discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Ms. Soriano, did you review what's entitled application for deferred adjudication or community supervision with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
We are, Judge.
And up to $10,000 fine. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand by entering this plea you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, or to find you guilty and sentence you up to 2 years in the state jail facility and up to $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I think so, Judge.
Off the record for a moment. Excuse me. This is not a massage parlor. He doesn't need you to massage him. You in the black, move to a different row. Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $500 fine to be probated. The state recommends deferred adjudication. There's to be restitution of $14,000 to the complaining witness. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea.
Yes, Judge.
State is at the plea.
Yes, Judge.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 4 years. There be 200 hours of community service restitution, and there's 100 hours in parentheses. Why is that?
Probated.
Desiree Serrano stands before the court facing a theft charge. The judge walks her through a detailed checklist of rights and consequences tied to her plea deal. She's told clearly, if her deferred adjudication is revoked, she could face 2 years in a state jail and up to $10,000 in fines. The courtroom tone is calm, but the pressure builds as the reality of what she's agreeing to settles in. This is more than paperwork. It's the first step toward accountability or a much bigger fall.
Probated. All right. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State officers to be.
No objection.
All right. State, you may be excused. Did you understand that today the state will be presenting evidence and the court will accept into evidence state's exhibits 1 and attachments, and the court will review the same? All right, the court will find there is sufficient evidence to find you guilty. The court will defer finding you guilty as you applied for deferred adjudication. So here's my question. It says the restitution is $14,000, but it says that she admits to taking between $13,000 and $14,000. Is there any proof of this? Does anybody know that it's 14,000 and not 13,000?
Well, Judge, other than what she says now, but
And how's
well, I don't think they have an itemization. They're going on her confession.
That's correct, John.
They don't have an itemization. No, they don't.
Well, it takes more than a confession to find somebody guilty. So entering a plea of no contest, you definitely need more than that. So with regards to the restitution amount, there needs to be something presented to the court. So I can figure out, 1, is she ever going to be able to pay restitution? And 2, what the restitution is. So is there anyone who can get restitution from Walmart? Something to show how much the specific amount is?
Right.
All right. So then what we'll do is we'll reset this for sentencing once we know the amount, and then I'll make a decision on whether or not I'll follow your agreement. Ms. Ferguson, can you recall this in 45 days for sentencing? All right. We're going to come back on October 28th. All right, once you sign the reset form, you're excused.
Thank you, Judge.
You're welcome. What page is she on? She's on page 2. All right, thank you.
Tension spikes unexpectedly as the judge interrupts to scold people in the audience, reminding everyone, this isn't a massage parlor. From there, things take a twist. Restitution is set at $14,000, but the court wants proof, and it's not adding up. The state can't produce receipts or itemize losses. Desiree's confession alone isn't enough, and the judge presses hard. How can someone be sentenced to pay back money with no solid evidence? The plea deal starts to wobble under the weight of missing facts.
All right, so this is being recalled, and the reason why it was being recalled because it had to do with the amount of restitution, correct?
That's correct, Judge, and you felt like the paperwork submitted. Well, no, Judge, we've got no more discovery. I thought maybe they would come forward with some itemizations. And it's,
All right, so part of y'all plea bargain agreement was the agreement of restitution of 14,000. So that's not a part of the plea bargain agreement?
It is, Judge.
A part of the plea bargaining agreement, Your Honor.
So then why are we having a restitution of $14,000 if you all agree that $14,000 is the amount?
Because you ordered it, Your Honor.
Okay, yes, so what do we have?
nothing further that was previously tendered for the court. I've been checking discovery on that, kind of thinking, so it may be that your concerns have not changed.
All right, because the police report says she took between $13,000 and $15,000. All right, we're going to go on the record. Court is calling 2023 CR 2580 State versus Desiree Nicole Sariana. Serini, how do you pronounce it? Sariana. Could I have parties announced for the record for the state?
Andrew Harris Edelman.
Defense?
Tom Beck for defendants.
And are you Desiree Sariana?
Yes, ma'am.
The case is reset for sentencing while the court pushes for evidence. The defense, confused by contradictions, admits no further discovery has arrived. The judge questions the $14,000 figure again, especially since the police report claims theft of between $13,000 and $15,000. If the amount was part of the plea deal, why does the state still have no proof? Everything stalls. What was supposed to be a simple deferred adjudication becomes a legal gray area, and Desiree's deal hangs in limbo.
All right, so we're back here for restitution because according to the police report, it says that they think she took somewhere between $13,000 and $15,000. So are you in agreement that it was $14,000 defense?
Well, she signed the plea bargain agreement.
All right, can you raise your right hand for me? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
No.
Okay. All right, so in the police report, this is Walmart, and Walmart says that the defendant admitted to taking somewhere between $13,000 and $15,000 of not placing money in the recycler. So how are you planning on paying this back? Where do you work?
In Amazon.
All right, are you making enough money to pay back $14,000?
Yes, ma'am. The payment.
One person at a time, please.
I'm sorry, what?
In payments? If I can do payments?
All right. So here's the thing. You were working at Walmart, and according to the police report, you took $14,000 because you needed for bills and housing and insurance. How is that any different working at Amazon? Is Amazon paying you more? And so
So I can pay the money back for.
all right, so if your partner leaves you, will you be able to pay this $14,000?
Yes, ma'am.
All right, people say that because they want probation, and then we end up right back here. I'm not going to do what other judges would do. What other judges would do would say they're not accepting this agreement till you pay the $14,000, and they usually would give you a month to come in with $14,000. So do you have a specific amount sort of as a down payment towards paying off the $14,000 that you can pay.
Back in court, the judge zeroes in. How will Desiree pay back $14,000? Desiree says she works at Amazon, but has no money on hand, no down payment, and her partner covers all the bills. The judge is skeptical. If your partner left, could you pay? Desiree says yes, but offers no actual funds. The judge does the math. 3 trips to court cost over $600. So where's the rest going? It's a reality check disguised as a sentencing hearing. And it's clear. The judge wants real answers, not lip service.
No, ma'am. What do you mean, like a down payment, something to start it off?
Yes, like $2,000. Do you have $2,000?
No,
How much money do you have to pay towards this $14,000 restitution today?
right now, nothing.
Why do you have nothing to pay if your partner is paying all the bills? What are you doing with your money?
She's the one that told me that, she would pay the bills for court.
No gum chewing.
So,
All right, so how much does it cost to drive to court from Amarillo?
like $100.
All right, so you've been here to court 2 times. This is your 3rd time.
$100 to come and then $100 to go back.
All right. So that's $600. So what do you have to pay towards this $14,000?
Right now, nothing. I can see what I can come up, like ask family members to help me out for a down payment.
Ms. Abrams, will y'all be able to put her on a schedule where she can pay off $14,000? Are you going to be able to pay $500 a month?
Yes, ma'am.
All right, Ms. Abrams, in order for her to pay off this $14,000, she needs to pay $500 a month towards restitution. All right. State, you may be excused.
Thank you, Your Honor.
Court is going to sentence you to 4 years deferred adjudication. There's to be no contact with Walmart. There's to be $500 per month for restitution. There's a $500 fine that will be probated. Proof of employment within 30 days.
The court lays down the terms. Desiree must pay $500 a month toward restitution. No contact with Walmart. No jobs involving minors or healthcare. She'll need to show proof of employment within 30 days, submit to random UAs, complete community service, and take a theft course. 100 hours will be waived after course completion, but she still owes big. This isn't a slap on the wrist. It's structured discipline, and any slip could bring the full jail sentence crashing down.
There's to be no employment as a home health care provider or with minors. There's to be regular reporting by Zoom or in person, regular random UAs. Do a transfer to Amarillo. What county is that?
I believe it's Potter.
There's to be 200 hours of community service restitution. She's going to do a theft course. Once you complete the theft course, 100 hours will be deducted. Do you have any children?
No, ma'am.
All right. And then she'll have to complete the remaining 100 hours of community service restitution. Probation, is there anything else she needs? Is there anything else you need from the court to be successful?
No.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing, when you come up short on your bills, stealing is not the answer, because then guess what ends up happening? You're still going to pay that money back. Now you have something on your record that's called a crime of moral turpitude, which is very bad. And this court, I require that you report. In order to be successful on probation here, communication is key. So if there's an issue, let your probation officer know. If you feel as though they're not addressing it, you can always come back to the court. Do you understand?
Yes, ma'am.
And you need to handle your bills and know that you need to pay $500 a month towards restitution. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome.
Thank you, Judge.
You're welcome.
With sentencing set and terms laid out, the judge delivers a final message. Stealing is not the answer. What starts as a legal warning turns into life advice. She explains how a crime like this sticks to your record. Moral turpitude, she calls it. And she leaves Desiree with one last truth. Probation success depends on communication. Handle your bills, report honestly, and don't let silence ruin your second chance. The session closes not just with orders, but with hope that Desiree might really turn things around.